3. In a rejoinder, Counsel for the Governor urges the committee to uphold the Governor's right to fair hearing under Article 50 of the Constitution and allow the application with a view to establishing the truth and proper facts as a quasi-judicial committee. Council has cited Rule 20 of Part 2 of the charge schedule of the Senate Standing Orders, which bars the County Assembly from introducing additional evidence that was not part of the allegations forwarded by the County Assembly to the Speaker of the Senate. 4. Having heard the parties, the Special Committee has deliberated on the question of whether to allow the Governor's application for new evidence and directs here as hereunder. This committee is bound to uphold the Constitution and has a duty to investigate this matter and seek to establish the facts of the matters raised therein. The committee is cognizant of the rules of evidence, the protection of the right to a fair hearing set out in Article 50 of the Constitution, and remains alive to the fact that to sufficiently carry out the mandate bestowed to this committee by the Senate, it may call for any information, document, or person that would shed more light on the matters that have been raised. On the request, therefore, it is clear to this committee that these are matters requiring evidence in order to prove and for which the other side has an opportunity of rebuttal. The committee can only make a fair determination having heard the evidence on both sides. This is the essence of this investigation. The investigation before the Senate is both in respect of the procedural as well as substantive matters. The committee, therefore, allows the request on the basis that the wider mandate of this committee is to exercise oversight function and flows from the powers in Article 125 of the Constitution. Based on the foregoing, this honorable committee finds and holds that the facts and issues herein can only be determined after the substantive hearing of both parties on the basis of relevant material and evidence on this matter, and that it is in the interest of justice that the Governor's application, that the supplementary affidavit and the flash disk be admitted to the record. In the interest of fairness, the County Assembly shall have time and be allowed the opportunity to cross-examine and rebut the evidence during the course of these proceedings. The County Assembly is hereby permitted to file and serve any response by close of business today. I thank you. Thank you very much, members. Now, we invite both parties to make their opening remarks. Each opening statement. Each will have an opportunity of doing so within 40 minutes, and we will start with the County Assembly. On behalf of the County Assembly of Meru, Council, you have 40 minutes.
Thank you very much, Chair and honorable members. We want to preface our opening statement by drawing parallels between Count 2, the second charge, Chair, that revolves around vilification and 8 campaigns against other leaders. And we want to draw parallels from world history in the hope that we will show you that the matter before you is a unique matter and that it is not too trivial with your time, that we have called you on Christmas holiday. Mr. Chair, if you check world history, there was a war called World War I. It was ended by the treaty establishing the League of Nations and the Treaty of Versailles, in which, among other things, it was resolved that that time the Republic of Germany would not do certain things in the hope that there will be never again in human history a war of such large scale. Shortly after the First World War, there came a leader in Germany between the year 1933 and 1945. This leader was very popularly elected, Mr. Chair. He enjoyed fanatic following throughout Prussia or Germany, if you like. This leader had little to no regard for other leaders or alternative views. But why we thought this is the right place to start, Chair, is how this single leader sucked the entire world into a world war. Just like the governor before you has a war with all the 69 MCAs, has a war with the speaker, has a war with the senator, has a war with the Catholic Church, has a war with any leader from whatever direction of the campus. That's exactly what this leader in Germany did, and specifically, the German leader militarized the Rhine region, which is the border between Germany and France to the southwest, in breach of the Treaty of Versailles. And Mr. Chairman, I make these remarks because we had our own world war in this country, called the post-election violence. We had our own Treaty of Versailles. We had our own Treaty for the League of Nations, and they are to be found in the Constitution of Kenya, 2010. They are to be found in the law on leadership and integrity. So how was the German leader able to suck the entire world into a war which some of our relatives, my grandfather, for instance, went to fight in Burma, in a war Africans had nothing to do with? So it begins by militarizing the Rhine region bordering France, effectively declaring law with France. How did the world powers of the day react, Chair? They said, let's make peace. Let it militarize, never mind it's unlawful, but we don't want war, we want peace. Because we are making this knowing you'll be told, let the MCAs go back to Meru and make peace with their governor. No sooner had he invaded or the militarized the Rhine region, then he invaded and annexed a country called Austria to the south, contrary to the Treaty of Versailles that forbade the union of Germany and Austria. So he is at war in the southwest with France, he is at war to the south with Austria. What does he do to the east, Chair? There was a small region in Czechoslovakia that he says has a few people who speak Germany. So he asks that Germany be allowed to annex that part. And of course, this was an act of aggression. Prime Minister Chamberlain in the UK, the American president, and the other people who would have stopped these gradual invasions decide, let him have that part. We want peace for our lifetime. In fact, the policy, those who have read history, was called the policy of appeasement. Let's make peace. If this leader wants this region, let's him have it. So he was given that region in peace. What does he do after that small region is invaded? He occupies and invades the entire of Czechoslovakia. What does he do in the northeast? He says there is a region in Poland which is on the northeastern border, and it is some few people who speak German. Therefore, it should be allowed to annex it to Germany. Again, this was an act of war against Poland. Prime Minister Chamberlain, Delano Roosevelt across the Atlantic, they are all deliberating on all these expansion and acts of war. And then they said, pursuant to the peace policy, let him have a small portion. Then what does he do after he gets that portion in peace? He invades and occupies the entire of Poland. Then, so far he has occupied France, Czechoslovakia, Austria. He had the UK now to invade. He discovers that he has to cross France through the English Channel to occupy the UK. Unfortunately, he didn't have a military, and specifically a navy, capable of beating the British military. So he decides he will overwhelm the UK through aerial bombardments. He's at war with the UK. Then as all this is happening, Joseph Stalin of the USSR decides, like everyone else, this guy is out to occupy the whole of Europe and to declare war against everyone. Let's make a peace treaty with him. And actually, the USSR signed a non-aggression treaty with his leader from Germany. And they sat on their laurels knowing that unless everyone else who was receiving a beating, they could relax because they had a peace treaty with Germany. What does Hitler do? Soon after signing the treaty, he declares war on the USSR and occupies the USSR all the way to Stalingrad, all the way to Moscow. Again, the world is watching and saying, we should not beat the bullet and remove this leader from power. Let's make peace with him. At this point, Chamberlain lost. By the time he was invading the USSR, Winston Churchill comes and calls the peace policy, the policy of making peace with this rogue leader. He says it is an unmitigated disaster and tries to persuade the United States to join them to liberate Europe from this rogue leader. The United States, just like the UK, takes a peace approach and says, those are your wars in Europe. You are 11,000 miles away. Why should we join you to fight Hitler? So America says it's not getting involved in anybody's war. 3 days later, Adolf Hitler declared war on the United States, a country 10,000 miles away, separated by an entire ocean. After that, Chair, Adolf Hitler decided he was not done with fighting countries. He decided he is fighting certain human groups. He identified Jews, Slavs, and whatnot. And to cut it short, Chair, by the time this rogue and untamed leader was done, the entire world from Japan to Australia to Africa to Americas was in a war created by one person, one leader, in what initially appears like small individual acts of aggression. None of them in isolation looked serious. And because of the policy of appeasement, by the time he was done, 50 million people were dead across the world. We are here, Chair, to hope to persuade you, based on the evidence we'll give you, that unless you help Meru County to tame this untamed leader, who is at war, just like Adolf Hitler, in all directions of the campus, who is at war with everyone, both real and imaginary, Chair, it will be an unmitigated disaster, to borrow the words of Winston Churchill. The motion before you, Chair, revolves around gross violations of the Constitution, gross violations of various county and national laws, abuse of office, and gross misconduct. It raises in total, although the counts are clustered. There are 6 main counts here, and when we listened, under each count, there are several specific allegations arranged thematically under 6 clusters. When you do your count, Chair, you will note the motion raises 62 violations, 6-2, of the Constitution and laws of Kenya, all committed within the remarkably short period of 64 days between 6th of September and 9th of November. So, Chair, you have an untamed governor who on average grossly violates the Constitution at least once per day. It must count for something, Chair. This motion was placed before the Assembly on the 14th of December. After listening to the evidence, Chair, there were 67 out of 69 members in the Assembly, and all of them voted to impeach the governor. The score was 67-0. When we get there, Chair, we'll be telling you that must count for something. Why must it count for something, Chair? The governor will try to persuade you that there is a gender dimension. And the question we'll ask and the Senate, if that is true, why did all the 23 female members of the Assembly vote to impeach her? We will invite you, Chair, to note when we get there that the governor was invited to respond to the allegations against her, and the invitation is at page 51 and 53. Rather, it is in our volume 3, page 49. And she did not, Chair, avail herself of that opportunity. To the extent that she did not take the opportunity to exonerate herself before the Assembly, we'll be urging you when we get there that it is trivial for her now to come before this Senate and tell you 1,000 ifs and buts. Chair, the allegations were read under the first thematic category of the violations. We will note you to note under the first charge, there are 19 violations. Under the second charge, there are 30 gross violations. Under the third charge, Chair, which is at ground 13, there are 4 gross violations. We will note you to note at the fourth cluster, there are 3 gross violations. And under the final cluster of the charges against her, there are 6 gross violations, making it the total of 62 that I alluded to. We will be presenting evidence, Chair, in the form of oral testimonies by the mover of the motion called Dennis Kiogora, by one of the MCAs called Mwenda Ivili, by a woman MCA called Lucy Mukaria, and a Catholic priest by the name Elias Kinoti. We will be relying on the motion itself and the annexes to it to show these violations, Chair. We will be playing before you the video clips that were submitted to the Senate and the County Assembly showing evidence of the violations. And of course, pursuant to your rules, we have filed witness statements that we rely upon. And in short, Chair, from the record you note, we have filed 5 bound volumes of documents that we'll be referring to show these violations. Chair, when we reflected on this matter, sometimes it is easy to be caught in the legalese, in the legal fine print, and to miss the big picture. we suggest, even as we must confront the legalese, even as we must confront the evidence and its merits and demerits, these are the overarching questions we suggest you will have to reflect upon, and just like the evidence should weigh on the scales, these questions equally should weigh in your mind. Question number one: why didn't the governor avail herself of the opportunity to defend herself before the assembly, especially when from the record, the documents she now purports to place before you, most if not all of them, by the date appearing on them, were in existence and were available and should have been available to her when the matter was before the assembly? Chair, the second question would be, would it be fair for anyone to argue or conclude that given all these fights with countless people, some of them not even in the county government, is it really possible that there is no fundamental problem with the governor on trial, and the problem instead lies with all these other people, the MCAs, the MPs in Meru, the senator for Meru, the cabinet secretary, the Catholic Church, the cartels, the corrupt? She has just too many people she has waged constant wars. Is it really possible, can we fairly say, that the problem lies somewhere but not with the governor? We will ask you to reflect on that in your minds. We'll be asking you, is it possible, and of course we know the Senate must make its own independent decision, and this is not an insult to the Senate, but is it possible that all these MCAs are misguided and all they have is misconceived? They don't know what is a gross violation of the law. They have imagined all these things, they actually didn't take place. We will ask you very humbly to reflect on that. The governor will come and tell you, because she has done so in paragraph 24 of our affidavit, that it is too early in the day for us to be bothering the Senate with an impeachment motion less than 3 months after a general election. Chair will be telling you that, one, our Constitution does not know this idea of temporary impunity, that there is a period following the general election in which governors have a blank check to do whatever heinous crime or misdemeanor they fancy, because during that period, shortly after the election, the Constitution is suspended. But we'll also be urging you, Chair, that that is exactly what informed the appeasement policy with Adolf Hitler. Chamberlain was saying, we just had the First World War. We just need peace for our lifetime. Let it be for now. We'll be urging you, Chair, to consider whether indeed, given the gravity of the evidence we place before you, whether we actually haven't taken too long to come before the Senate. And our case will be that it is not too early. We have actually taken too long. We would have arrived much earlier had the initial process not been quashed at the High Court of Kenya through for purely procedural grounds. Chair will be asking you to ask yourself the question, because the governor again has raised this issue in paragraph 3 of our affidavit, in paragraph 11, in paragraph 12 and 15. She tells you all these problems are because she's a woman. You know, if she wasn't a woman, she would not be subjected to all these problems. Chair will be inviting you to ask yourself, if that were true, how come all the women MCAs voted to impeach her? She cannot be the only woman in the government of Meru who understands gender issues. She will try to tell you, Chair, That forget this motion and the 62 allegations. She will tell you that's language used in her affidavit that is about the Ward Development Fund. That's why the MCAs have collected all this litany of accusations against her. It's within her right to raise it, but we'll be asking you, Chair, to ask yourself, if that were really the reason, why did the nominated MCAs, 24 of them, who have nothing to gain or lose from the ward fund, the operative word, Chair, is that they have nothing to gain or lose, which means they have no interest in that issue. Why did they also vote to impeach her? We will ask you, how come the other women governors in Kenya and in the region of Mount Kenya are not having these types of problems? She will tell you it is because she is an independent. She ran as an independent candidate. That is why she has these problems. And the question we'll be asking you to ponder over, whether that is true or not, is if that were true, how come the independent MCAs in the county assembly, who are not affiliated to any party, also voted to impeach her without exception? Chair will be asking you the broad question, if we are able to persuade you that the Assembly has good evidence of the allegations, the question we would urge you to ponder in your mind is whether the Senate should look the other way around, should excuse these heinous crimes and misdemeanors because either it is too early or because the offender is a woman. Chair will be asking you to ask yourself, based on the words I began with about Adolf Hitler, should the Senate, just like the Prime Minister of the UK then, just like Joseph Stalin in the USSR, just like Delano Roosevelt in the US, should the Senate equally adopt the policy or the stance of peace? You guys, go make peace. It is too early in the day, and our submission when we get there, Chair, is we are dealing with the megalomaniac of the type that was ruling Germany between 1933 and 1945, who is at war with everybody in all the four corners, all the four main directions of the campus. I know Chair is consulting. I don't know whether I should proceed, Chair. Okay. Chair, I noted you were consulting, so I didn't know whether to proceed. From my profession, if you see the judge consulting, you pause.
Yeah, it's good you paused, eh?
Yes.
And you are free to make your statement.
Yes.
But be careful.
Yes.
About the words you use.
I'm guided, Chair.
Yeah, words like megalomania. You've quoted enough from Hitler. Make your case.
I'm guided, Chair. Thank you very much for that guidance. Chair, the point I was making is, at the end of the day, besides considering the evidence and the merits and the demerits, we cannot run away from the question whether should you direct the county government of Meru to go and make internal peace, and we'll be urging you that would be an untamed or rather an unmitigated disaster, given the type of allegations before you, especially those at the charge number 2. Chair, there will be questions you have to consider whether impeachment is counter-democratic. Because the governor will come and tell you from our affidavit, the Assembly is trying to reverse the will of the people. When we get there, Chair, we invite you to note, just like the Supreme Court has noted while upholding this Senate's decision to impeach the governor of Nairobi, that there is nothing undemocratic about impeachment. On the contrary, impeachment is a constitutionally ordained safeguard for dealing with what we would call the aberrations of democracy. They say, Chair, democracy is the best form of government, except that there is no other. And when we get there, we'll be showing you democracy actually sometimes produces aberrations, counterintuitive results. And the makers of our Constitution, being conscious of the possibility of democracy giving you. I know the chair is consulting again, so I don't know that my time will be stopped here when they... So Chair will be inviting you to note.
You will have an extra 2 minutes.
Much obliged, Chair. We'll be hoping to show you that, one, the claim that asking you to impeach is counter-democratic and it is overturning the will of the people is not correct for several reasons. One of them is that impeachment is a constitutionally ordained mechanism for dealing with leaders of the type we have brought before you. We'll be telling you the claim that the governor was vastly elected, the exact language she has used to support that argument is that she was elected by a vast majority, is not correct. When we get there, we'll show you actually she was not even elected by a majority in the first place, leave alone a vast majority, because she was only elected by 41% of the persons that turned up at the ballot. Chair, she would also try to ask you to read. We have taken the liberty to bring to you both a public participation report and the raw memoranda submitted from all over the county. And we'll urge you, when you read them, you will actually find it is not correct to suggest that impeaching this particular governor would be counter-democratic or a reversion of the will of the people. In short, Chair, we'll be coming before you to tell you that Meru is in crisis. And this crisis, if led to fester on, especially under a thinking of appeasement, a thinking of it's too early, a thinking of gender, we do not know whether Meru might turn out also to be another unmitigated disaster. Especially, Chair, when you're told the governor is not only fighting every passing day other elected leaders both at the national and county level, but she has also roped in the church. She is also at war with the church. Why is this a potential for an unmitigated disaster, Chair? We know what religious incitement did in Sudan, now split into Sudan and South Sudan. We know what religious differences have done between India and Pakistan in a place called Kashmir. We know in the UK, our colonial masters, what religious differences and incitements between Catholics and Protestants in Northern Ireland has caused for the last countless decades. We know, or should know, what religious incitement is currently doing in the Central African Republic. We know, Chair, or should know, something called the Biafra War in Nigeria between the North and the South, basically along religious lines. And Chair, what we have come before you is to tell you we are at the siege. Meru County is at the siege. We have come to you as the custodians of the devolved government to tell us, yes, this governor was elected by the people. She was elected democratically. But in this case, just like the country in Europe I began with, democracy has produced unintended consequences. And because democracy has produced consequences not intended, we must look at the solution the wise drafters of our constitution put in place to deal with those consequences before they become an unmitigated disaster. And that solution is in Article 181 of our constitution, as read with Section 33 of the County Governments Act, as read with the Standing Order number 65 of the Standing Orders of the County Assembly of Meru, as read with the Standing Orders of the Senate and the schedule that sets the rules. We beseech you, Chair, please don't let Meru become an unmitigated disaster. In the Christian Bible, Chair, there was a guy who was in a boat and a storm came, and the people navigating that boat had to make a hard choice. Do we let everyone in the boat perish, or do we sacrifice one person who is the cause of the storm? Do we let Meru County, with a population of 1.5 million people, go to the dogs? Or do we jettison the one citizen of Meru, much as it may pain us, much as we may be reluctant to do it? But at the end of the day, we urge you to do it because it is the right thing to do, it is the fair thing to do, and it is the only pragmatic solution to the problem in Meru. Thank you very much, Chair. Unless there is a question for me, I beg to take my seat.
I beg to take my seat.
Thank you very much. Senators, I don't know whether you intend to comment anything on the statement. I don't think so. We just let it hang. Yes, Senator Fonarobi.
Chair, the Council for the Assembly has taken us through the explanation of whether an impeachment is counter-democratic. I would want him to also address the question of whether a discharge of the governor from all the accusations that have been made here, if they are disproved, or whether if the threshold is not met, if that would also be counter-democratic in his view.
Yes, Council, you asked for it. You know, ordinarily we don't want to field questions now, but you asked for it.
The Senate is within its right, after hearing the evidence, to either confirm or dismiss the case. Therefore, there will be nothing counter-democratic in the Senate discharging its power one way or the other, because we didn't come here having assumed we must win our case. It must be taken that the person reposed of the ultimate power is the Senate, and the Constitution has empowered Senate to make that decision. Therefore, there is nothing counter-democratic to it. The only disclaimer is that even as I make that, is the question I asked. It cannot surely be that all these people at the national and county levels of government and in the church are the problem, and the governor is a saint. It must count for something.
Chair,
members, I don't want to open it, but
just one clarification, Chair, because I might have put it wrongly. Whether he equates a discharge of the governor to the policy of appeasement that he has taken us through the leadership of Europe and America during the First World War, whether he equates it, a discharge of the governor, to a policy of appeasement by the Senate.
Council, just hold, take all three, and then you respond. Yes, please.
Thank you, Chair. Chair, the learned friend has said democracy has produced unintended consequences. Unintended consequences. It's Chair, I can imagine, the country has just gone through a general election, which was democratically done. Would he then be saying that as long as the results did not produce the person for any level or for any seat that he so wished, then it will be unintended consequences?
Thank you. Thank you. Senator Kiambu.
Thank you very much, Chairman. Mine is to wish if we were to listen to the opening remarks from the other side, because the council has alluded that in the Bible they had to sacrifice somebody by throwing him into the sea, and that person had to be swallowed by the fish, and he went to another city to give good news. So, and that is Jonah. So probably if we give the governor, maybe he has the news. So we better listen to that side before we make other comments. Thank you.
Yes, Vice Chair.
Thank you, Chair. Following the same question that Senator Fokajado nominated us about the lawyer saying that all these people, the MCs and the church and the people who are accusing the governor, I want to know from him, which are the majority, the people who elected the governor or those people you've mentioned? Which are the majority?
Thank you. Yes, the Senator from Migori.
Thank you, Chair. And thank you, Council, for a fantastic introduction, or rather opening remarks. I think I wanted to, through you, Chair, further the thoughts by Senator Tobiko, because I find some very critical aspects of it with regards to what we are about to further hear from the Council here, which is the notion of the people of Meru getting justice ultimately after the election. The Council has said that democracy has led to unintended consequences. In your view, Council, may you guide us as a committee how to assess this with respect to the people of Meru who voted for the governor? How does this committee assess what you have termed as unintended consequences with respect to the people of Meru who are today probably suspending all their activities that could amount to a GDP of over 1 billion or 2 billion watching these proceedings? Please guide the committee on that particular statement.
Thank you.
One last question.
Yes, please.
One very last. Chair, I also wanted the learned friend to tell us if he's aware that the Kenyan electoral system is first past the post. When he says that it's only 41% who voted for the governor. The Kenyan system is simple majority, even if it is one person past the post. Can he tell us if he knows that?
Thank you. Edwin, you had something to follow? Sifuna? That's okay. Very well. So, Council, those are, just be seated. Council, be seated. Yes, yes. Those are not light questions. Just like you prepared your statement, also prepare to respond on everything in a considered manner. So we will protect you. The counsel for the governor is going to also make his opening statement. Meanwhile, you can choose to respond to us now at the right time when you are prosecuting your case. We will protect you, don't worry. I know members are very sharp when you tell them about the law of, the unintended consequences. I was thinking you were saying it with a light touch, a question of language, the law of unintended consequences. The farmer plants on his farm hybrid maize. The neighboring farm plants kienyeji, which is purple in color. And the guy with the farm of hybrid then harvests maize, which is not purely hybrid. The guy of the farm who planted hybrid did not intend to have that consequence. It was unintended. I thought it was light touch, but you asked for it. You will have to lie in that bed yourself. Governor, you are now invited.
Thank you, Chair, for the opportunity, and good afternoon, honorable members of the Senate. Mr. Chair, my learned friend, Mr. Dr. Muthomi Thiankolu, has been very colorful in his opening remarks. I have a disclaimer that I'm not a very good student of history, or I might not be as philosophical as he has been. I'll therefore stick to the issues before the Senate. I'll stick to the facts. I'll stick to the law. And that is what has brought us here today. Honorable members.
Sorry, before you address us, the record has not answered, has not captured your name. So introduce yourself fully, and then you proceed.
Much obliged, Honorable Chair, and apologies. My name is Elias Mutuma, one of the councils representing the governor in these proceedings. Members, Learned Council has used a lot of strong terms to describe the governor of Meru. Council has painted a picture of a crisis that is in Meru. He's called it unmitigated disaster, a crisis, and gone ahead to equate the governor of Meru with Adolf Hitler. We will be demonstrating that that is a creation by the MCAs, and that indeed the people of Meru do not perceive any crisis. They do not see any threat to them, that this is a contest between the executive of the Meru County and the legislature. Honorable members, we stand before you today to represent the governor who was elected by a majority votes. The closest contestant garnered less than 100,000 votes next to the governor. Surely that means that the governor was voted in overwhelmingly. Honorable members, this is a second impeachment motion. The first one was stopped by the High Court in Meru. and that conservatory orders were issued preventing the county assembly from in any way debating the impeachment motion, but in defiance of the court orders, they proceeded to do that. A question has been asked as to why the governor did not appear to defend herself before the county assembly. It is for the very reason that indeed the High Court of Meru had barred the county assembly from debating the impeachment motion. Our client risked being in contempt of court had she participated in those proceedings. So that should be able to answer the question as to why the governor never appeared before the county assembly of Meru. But that is not all, honorable members. That is not all, honorable members. Impeachment proceedings, and the High Court, the Supreme Court, and the Court of Appeal has given this guidance that they are quasi-judicial in nature, that the county assembly ceases to be a legislative house and assumes the role of an arbiter to investigate and establish whether indeed facts that have been tabled before it are correct or not. We will have evidence before this house showing that indeed the entire house was not impartial. Before the proceedings, they all donned in uniform, chanted war cries, and promised to impeach the governor even before the move of the motion had been given a chance to debate the motion. Our simple argument to that extent is that the house was not impartial, and that had been demonstrated even before the impeachment was properly placed before the House. The governor is here to answer to the impeachment motion approved by the
governor is here to answer to the impeachment motion approved by the County Assembly of Meru and to demonstrate her innocence and give a side of the story. Her Excellency, the Governor of Meru, has been a victim of the danger of one story and outright false narrative. Her successes, her leadership, her amiable character, and her passion to uplift the lives of people of Meru have been hashed for political expediency. Today we have a chance to demonstrate that Her Excellency, the Governor, is a true hero of devolution, a person who should be celebrated for standing against capture of Meru County by the County Assembly. At the end of this hearing, honorable members, we demonstrate how the County Assembly of Meru failed to understand their mandate under Article 181 and Section 33 of the County Government Act and used the impeachment as a political weapon as opposed to an oversight tool. Because impeachment, honorable members, should not be a political weapon. It is only provided for as an oversight tool. That is not what happened.
We will show you that the purported public participation was a sham. Indeed, the members of public have not approved the proceedings before you. It is the County Assembly of Meru and the mover of this motion that usurped the role of the public and purported to give views on behalf of the public. That will come out clear during these proceedings. Honorable members, just to take you a little bit back, before August 2022, Her Excellency the Governor was serving the people of Meru as their women representative. During that time, she understood the real needs of the people, leading to an expression of desire to serve them as their governor. The people of Meru trusted her and gave her a chance to serve as their first woman governor, elected on an independent ticket. And this is important, honorable members, because Meru traditionally has been a political region. So for them to elect a woman governor and on an independent ticket, then that should mean something. Unfortunately, the governor faces impeachment, just like the first woman member of parliament in Meru, Honorable Rita Karemi. And this is a woman who was rounded out of office on trumped-up charges. We are back at it again, and we urge the Senate to look at the issues before it and find that indeed the governor has committed no wrong. We know that there has been much debate about the gender question, but the real issues affecting women leadership and the governor's unique challenge as an easy target for blackmail and subjective application of the law, being an independent candidate, should not be swept under the carpet. We are also aware that the County Assembly has listed a woman-nominated member to appear before this committee today with a view of discounting the argument on challenges faced by women leaders, which evidence we will ask the committee to treat with much suspicion and look at the facts of this case to grant the governor equal protection before the law like any other person. We wish to categorically state that the governor has never sought to be excused for any wrongdoing just because she's a woman. All she's asking is to be subjected to an independent and impartial process, but not to be subjected to an impeachment on the basis of political reasons moved by a member of County Assembly, Dennis Kawira, who, and we show this evidence, is quoted saying, or rather inviting the governor to prove that she's a woman enough. It is on that context that we are bringing the gender issue, not asking her to be excused on the basis of gender. Honorable members, the governor has been a victim of many falsehoods, contrary to the false narrative of public disapproval created in the impeachment motion and spread strategically in the public domain through the media. The people of Meru have expressed their overwhelming support for her leadership, and in reflection of their resolve and approval for her leadership, they have not been deterred by a parochial culture or party politics and elected her into office, having observed her work as their women representative and having believed in her passion for a happy Meru, a quest she has expressed in her personal philanthropic work that she has done together with her husband over the years. Her husband did not just come to the public domain upon her election as governor. Notably, honorable members and chair, during the August 2022 general election, other leaders were elected mainly on party positions, but she was elected as an independent candidate in demonstration of the people's approval for her personal and individual leadership, regardless of political party support. Contrary to the false narrative presented in the impeachment motion, her leadership as a person has been tested and approved without any support of a political party and facing opposition from the veteran politicians in Meru. Her election is a clear demonstration that she is a leader who has appealed to the people owing to her personal character and leadership ideas. Her passion to uplift the people of Meru is not new in this, and this has been a mantra even before she ventured into politics. She has helped many people in Meru in her charity work, and this has won hearts and approval to elect her to bring changes in service as their governor. Honorable members, you will see from the evidence on record that the governor is very passionate about what she believes in and sometimes emotional about it. Honorable members, it is not a crime to be emotional. It is not a crime to be passionate about what you believe in. In some instances, the governor seeks to give instant solutions to the problem she faces when she meets members of the community. But then, even after making those political statements, she retracts and seeks advice and is guided and does things according to the law. She has not at any point violated the law, leave alone grossly so. Honorable members, let us understand the governor as who she is and give her an opportunity to serve the people of Meru. We understand that we are barely 4 months after the general election of August 2022, and the new national government has already faced this self-same challenge of not meeting their political promises, and as envisioned during the political rallies, since the law has to be followed in implementation as per the advice of technical experts. We also wish to point out that the governors are also political leaders and wear two hats, one political and the other technical. In politics, political statements often made to give hope to the people and such pronouncements may not capture the nitty-gritty of what should be done, but a leader has to give hope to the people upon encounter with problems. In governance, the governors often retreat to consult with technical advisors to ensure execution is done within the law, to meet objective and vision in any political pronouncement. Honorable members, a politician cannot be prosecuted and accused of gross misconduct or gross violation of the Constitution for political statements with no evidence or execution that violates the law. So when we'll be going through these proceedings, honorable members, you will come across so many political statements made by the governor. But was there any act that proceeded to violate the law based on those political statements? The answer is in the negative. The governor's passion for the people has also led her to engage the people at grassroots areas, constantly to fill all the needs in every ward, a move that has been misinterpreted by the MCAs as overshadowing their presence in their areas. However, she has compromised this style upon a request of MCAs in a mediation meeting she undertook with the chairperson of the Council of Governors with a view of giving chance to dialogue with the MCAs. Since she was elected into office, the governor has struck a collaborative style of leadership. Contrary to what has been said in the impeachment motion, the governor has indeed embraced a collaborative style of leadership, working with all stakeholders and leaders in the county, contrary to the false narrative run in the impeachment motion that she works in isolation. She has made tremendous efforts, humanly possible, to engage the elected leaders in Meru County, but they have turned down our requests time and again. She has regard of all elected leaders.
Turned out to be what? They have turned out to be?
They have turned down her request.
Oh, okay.
Yes. She has regard for all elected leaders, and the evidence to be presented will demonstrate this. In bringing the leaders of Meru to work together, the governor has sought a consultative forum from the MCAs, which has been snubbed. She has also followed up on the request of MCAs, including a demand that her husband ceases to attend official public functions. If you note, honorable members, the spouse of the governor has not made any public appearance from 26th October. That was based on a demand by MCAs, and the governor went out of her way to ensure that indeed she has cautioned her husband to stay out of the limelight, if indeed that was the problem with the MCAs. The members of the County Assembly have, however, been impatient and uncooperative in many ways, mainly putting demands that extend to an overreach of their mandate and a desire to usurp the functions of the governor. The MCAs have constantly, openly said that the governor must listen to their demands before they can do their work in the County Assembly. It is in the law that she should make a maiden address in the County Assembly. You will realize that one of the charges, honorable members, is that the governor tried to force her way into the County Assembly. The maiden address by the governor is a statutory requirement, and indeed, the Speaker of the County Assembly of Meru gazetted that day when the governor was supposed to appear before them and address them on that issue. The governor, in that invitation and pursuant to that gazette notice, appeared before the County Assembly, and to her shock, the County Assembly doors were locked. However, she was still ushered in later by the Speaker of the National Assembly. The Speaker of the National Assembly ushered her into the podium to deliver her maiden speech, which she did, but the moment she rose to do that, members of the County Assembly walked out on her. How can they accuse her of then making a forceful entry into an assembly when that very day was gazetted and an invitation sent to her? There was no gazettement of that day. There was no cancellation of the invitation. Yet the members of the assembly will come now and tell you that indeed the governor forcibly entered into the County Assembly. Honorable Chair and the honorable members, the governor has been a primary target and a recipient of the gory and ugly actions that she has been accused of perpetrating on other leaders of our beloved county of Meru. There is no single evidence from any of the elected leaders in Meru, be it the senator, be it the cabinet secretary, that has come out to claim that they have been disrespected by the governor. There is no single affidavit produced in support of that allegation, and therefore we are inclined to say that indeed this is a creation by the MCAs and that other leaders in the Meru County are in good working relations with the governor. Indeed, honorable members and chair, you will find a letter by the governor herself inviting all elected leaders, including MPs, senators, MCAs, for a consultative meeting at the official residence of the governor. None of the leaders appeared. If indeed the governor was not keen in working with other leaders, why would she officially invite them to a consultative meeting? Why would they snap that meeting? Who has the problem? Is it the governor or the MCAs? Honorable members, we are happy that the law grants the governor this chance to demonstrate her innocence before you after being victimized in a political process of impeachment conducted by the County Assembly of Meru. As we answer to the impeachment motion in the course of this hearing, we shall be able to demonstrate, one, that the impeachment motion introduced, debated and passed in the County Assembly of Meru was unjustified, and the sole motivation was the personal interests of few at the expense of service delivery of the people of Meru. The impeachment motion debated, passed by the County Assembly of Meru did not meet the threshold on the grounds for removal as envisaged under Article 181 and Section 33 of the County Government Act. The mover of the motion did not provide any evidence, just like before this tribunal, of any value in support of the motion, apart from very sentimental quotations and assertions. The purported public participation in support of the motion for impeachment was a sham, a creation and imagination of the mover of the motion without any public approval in affront to the Constitution. We shall demonstrate how low the County Assembly went in desperation to tick the box of public participation. Citizens who supported the governor and desired the motion defeated were beaten, harassed, insulted, and violently chased away from the grounds when the sham public participation was being managed. Suffice to note, honorable members, that the public participation exercise was being spearheaded by the very MCAs who are the accusers in this motion. Mr. Chairman and honorable members, the governor has been accused of failing to work with other leaders in the County Assembly. At the end of the hearing, we will demonstrate that the allegations against the governor in the impeachment motion have not been substantiated as required in law. You will get a chance to peruse the documentary affidavits and evidence that we have tendered. You will hear the governor's witnesses and the team of advocates that will be able to demonstrate this fact. In conclusion, you discover that the following evidence to be presented is watertight. One is that this is a case of impeachment being used to coerce to settle political scores. The MCAs were forced, threatened, and coerced to vote in favor of the motion to an extent that 2 members were de-whipped from their committees. We shall demonstrate why the nominated members had everything to lose by not supporting the motion. The governor is a victim of blackmail and an easy target by the County Assembly for being independent against a united minority and majority sides of the County Assembly. The main issue that triggered the filing of this impeachment motion is the demand, and we say the demand for ward fund by MCAs, and all other allegations are peripheral to that allegation. We have evidence to that effect. The impeachment is not approved by the voters of Meru County, contrary to the impression created by the shambolic public participation exercise. The question that begs an answer is whether this motion is supporting the will of the people or against the will of the people of Meru. We submit that this is a case of abuse of power, where again MCAs are using impeachment as a weapon as opposed to a tool for oversight. The allegations cited in the impeachment motion cannot form a threshold for impeachment and are full of outright falsehood and political statements taken out of context with no evidence of violation of the law. At the end of this hearing, we urge the Senate to find that the allegations cited for impeachment have not been substantiated as required under Article 181 and Section 33 of the County Governments Act. The process did not comply with the law, and the same cannot be sustained by the Senate. Honorable members, I respectively beg to sit down unless you have any questions for me. Thank you.
Thank you very much. You have kept time, and just like we did in the other case, maybe, yes, Esther, somebody has something to say?
Yes, thank you, Chair. I have a question for him. From your opening remarks, you already indicated this was a partisan process. What would you associate the witch hunt with? And given the accusation that came a short while after elections, what would you attribute these to? Do you think it's misunderstanding due to team dynamics? I would be looking forward to listen to what you have to say about that. Thank you, Chair.
Senator Ali Roba.
Thank you very much, Chair. Mine is to request the council. He made, the statement that MCAs spearheaded the public participation exercise.
The public participation exercise, strictly legally speaking, in your view and in accordance with the law, who was supposed to spearhead public participation?
For Migori, Senator Okech.
Thank you, Chair, and thank you, Council, for an excellent introduction or opening remarks. Highly appreciated. Two quick comments. Chair, the Council has indicated that this impeachment is at the backdrop of a court order, and I just wanted to seek whether the Council is in congruence with the understanding of this committee that the determination of the constitutional petition number E024 of 2022 was on the basis of the first motion that the Assembly had, and the hearing you're having now is on the basis of the second motion, which has got nothing to do with constitutional petition number E024. That's the first comment. The second comment, quickly, Chair, the Council has made a very strong statement intimating the passionate nature of the governor, to the extent that some of the allegations do come out of political statements, which the Council has indicated that some of these political statements cannot be basis of accountability to the extent that warrants impeachment. Council, guide the committee, perhaps with regards to Article 179 of the Constitution, specifically Section 4 of that article, sub-article 4, which establishes the governor, and I think is the only officer elected under law who is subject to be an executive voted for. And with regards to that as well, read it together with the County Governments Act, section number 30, which establishes the functions and responsibility of the governor. May you guide this committee whether those political statements are not in respect with those two provisions of law. Article 179 of the Constitution, Sub-Article 4, and Section 30 of the Counties Government Act of 2012. Thank you so much.
Thank you, Okech. Senator for Nairobi.
Thank you, Chair. Perhaps to help my brother Eddie. Counsel, you have made reference to a court order at the inception of some of his proceedings. We want to know the second impeachment motion, which is the basis of his proceedings. Was there a case filed? Was there any order barring the Assembly from proceeding with that second impeachment? Number two, is it your position that you cannot, in fact, violate the law by pronouncement? Is that the position that you want to give us, that you can, in fact, not violate the law by a mere pronouncement?
Perez.
Thank you, Chair. Chair, the Council has said that sometimes the utterances of the Governor are emotional and passionate, but later retreats to seek legal and technical advice. Chair, I don't know whether the Council can clarify whether the Governor understands that it should be the other way around. I'm not giving an opinion, but I think he needs to clarify that.
Thank you.
Whether that's the ideal situation.
Tangwa.
Thank you very much, Chair. My question is only one to the Council, and it revolves around the Ward Development Fund. Because the Council has said that all this started because the Governor has refused to give the MCAs the Ward Development Fund. So I wanted to understand at which point did the Governor refuse, or is purported to refuse? Because I do understand for an assembly is a legislation body, so they're supposed to come up with this law, pass it for the Governor to assent. So did they go to that stage of passing this law, then the Governor refuses to assent to this law? That's all.
Thank you. That is all. Yes, that is all. Council, we will give you time to respond to these issues. But members, I was thinking, we remind ourselves the matter raised by Senator Okech and supported by Senator Sifuna on the matters of the High Court orders that were delivered in respect of the first impeachment motion. That matter, Mutuma and company advocates, they wrote to the Speaker of the Senate. And from what we are hearing, they have not challenged our jurisdiction. So since they are not challenging our jurisdiction, we shouldn't go there. You don't have to really burden yourself with that. If it was an issue, you would have challenged the jurisdiction of this sitting. It means they respect this sitting. That's why they are here. Let us discharge. Finally, in our program, we were supposed to receive evidence from the County Assembly at this point between 12:40 and 1 o'clock. But if you look on the clock, it is 1:17. So I wanted to request members to manage time. We give 5 minutes to both sides. They address the issues we have raised. Then we adjourn for lunch. And when we come back, we now hear evidence. Would that be okay, members? Thank you. So, County Assembly, issues raised.
Chair, questions were asked as to what I meant by unintended consequences, and whether by that I meant my preference of who should have been governor or the preference of the MCAs as to who should have been governor. The answer to that question is, when the people of Meru went to vote, they did not vote the governor to be fighting other leaders. they did not vote their governor to be usurping the statutory functions of the County Public Service Board. So that is what I meant by unintended consequences. In fact, Chapter 6 is loath to such a governor or any other leader who engages in such behavior. So it must be then an unintended consequence. Then I was asked, would a discharge of the governor be analogous to appeasement policy that European leaders and their American counterparts had against the warmonger in Germany? And I think I answered that question and said, this House has all the rights. There's an unqualified right to make whatever decision it wants after hearing the evidence on both sides. No one can be hard to fault the Senate because they decided the matter one way or the other. At any rate, the Senate must decide it one way or the other anyway. I was asked, how do we compare the people who voted for the governor vis-a-vis those who voted for our accusers, the MCAs, and the people who have all these complaints? Our answer is as follows. Number one, the governor was not the only leader elected in Meru. The people of Meru equally elected the MCAs, who she is at war with without good cause. The people of Meru elected their senator, with whom she is at war with. The people of Meru cast votes they were not sufficient to return the cabinet secretary, who she is at war with. The people of Meru voted the MP for Tigani East, and indeed all the 9 MPs. Therefore, it cannot be taken that the Honorable Kawira Mwangaza is the only person who was voted in Meru, or that somehow there is something special about the votes she garnered. The entitles are therefore to have these false accusation and vilification campaigns, which we hope will persuade you when we get there. What I meant by the issue of where do we place the people, we have already placed before you, and we'll get there, the public participation results. And they tell you, while as the people of Meru may have a certain opinion as at 9th August when they cast their vote, supervening events, specifically the events mentioned in the impeachment motion, have tilted that will of the public or the voters of Meru, and we'll get there when the evidence starts flowing. Questions were asked whether we'll be impeaching the governor so shortly after an election. And the question, the answer, Chair, is we will be creating a very dangerous precedent to say it is too soon, because what you will be establishing is a precedent that tells any other governor that you can engage in whatever misconduct you fancy. You can go breaching the law in all 4 directions of the campus, because it is too early anyway, nothing will happen to you, and we will have declared that Chapter 6 of our Constitution stands suspended the first few months, first few weeks, or whatever days after the election. There was a question about the fast past the post. It is true that our electoral system is fast past the post. But that is the more reason why anyone accused of these heinous crimes should be very careful before roping in the people and saying the will of the people. Because although my colleague told you she beat the next candidate by more than 100,000 votes, It's in the public domain. The votes were as follows. Kawira got 209,148. The Honorable Linturi got 183,859. The Honorable Kreitu Murungi got 110,814. The will of the people, Mr. Chair, must be taken as including these people who also voted for Linturi and Kreitu, who when combined anyway are more than the people who voted for the governor. And merely because the system is fast past the post does not mean the will of all those other people who are actually more counts for nothing, and therefore the MCAs they elected should be insulted every day, should be vilified every day, and no other things that we've placed before you. There was a question about, I think my colleague said about public participation. When you get there, Chair, we have our volume 4, and it will show you 2,734 persons signed 300 written memoranda in support of the impeachment motion. It will show you only 30 persons, 30, sent memorandum in favor of the governor, and because we love full and frank disclosure, we have attached even those memoranda that were sent in favor of the governor, the 30 of them. More than 1,080 persons made oral representations, and out of those 1,080, it is only 260. All these can be confirmed by your Secretariat Chair from our volume, who expressed oral views against the impeachment motion. And that is what we meant, whether it is really true for the governor now to wear the cloak of the people. It is the easiest thing to do. Perhaps I would do it if I were in her shoes. But the fact that I would do it also if I were in her shoes doesn't necessarily mean it is valid. I think the role of the Senate is to interrogate it and ask itself whether really that is a valid response. And in any event, Chair, even if we were to assume for argument's sake that the Honorable Governor was elected with a 100% majority, would that be a valid answer to the accusations against her? I'm just checking, Chair, whether there is a question I may not have responded to. But I believe they have responded. There are questions, Chair, that the mover, I think this is the last one I have not commented on, that the mover of the motion has said an axe to grind with the governor, dating back to even the electoral period. We do not know, and we'll leave it to you to decide whether that is true. But we have to remind you, the matter before you is a decision endorsed by the County Assembly of Meru, and that there are safeguards in law to ensure that impeachment is not intended to serve personal cause. One of those safeguards, Chair, is the mover has to get at least 2/3 of the members of the Assembly to append their signature before he can even present the motion to the clerk. The second safeguard is that in addition to signing on that motion, the MCAs have to verify their signatures with the clerk so that they are not allowed to say, I was drunk, or someone brought me a document to sign and I didn't. In addition to signing the motion, they have to sign a verification signature. The matter has to be prosecuted before the Assembly with the governor given a chance, that safeguard. And at the assembly, the mover of the motion must secure a minimum of 2/3 of the MCAs before the matter can be escalated to the Senate, and if he fails to do that, it heads. Before this Senate, Mr. Chair, the Assembly, the mover of the motion, must still get a majority of the delegations to succeed. So it doesn't matter anyway, given all these safeguards, and there are many others. For me, it is a diversionary tactic. Again, perhaps if I were in the governor's shoes, I would say exactly that. The fact that I would say it does not necessarily mean it is correct or that it should be believed. I hope I've addressed all the questions, Chair.
Yes, indeed, but just in case you've left something out, we will still allow you to refer to it as we go along. We want you to exhaust your opportunity completely. Governor?
Thank you, Chair and members, for the questions. I'll address two, then my learned friend, Mr. Mwangi, will address the rest. One is a question on whether there has been any law passed. This comes from the Senator of Kiambu, that directed the governor to utilize, or rather to disperse the ward fund, and the governor refused to assent to that act. There has been no such act by the county assembly. What is there currently is that we have an approval of the ward fund by the previous government of 10 million per ward, which the governor has already dispersed to the 46 wards within Meru. But what the MCAs were doing is to demand an extra, because there was some disbursement which was not clear from the previous governments of 20 million, 25 million, and you see that from record from the previous governments. So they wanted the governor to continue with that trend, and the governor said, I'll only do that within what the law provides. And to that extent, the governor sought an advisory from the Controller of Budget. The MCA sent a delegation to that effect, and they were accordingly advised on how to utilize such funds. So it is not true that the governor has refused to assent to any law that the MCAs have passed. Secondly, on the issue of public participation, we submit that public participation should be objective. It cannot be subjective. And that's why you cannot be the investigator, the accuser, and the judge at the same time. So if the MCAs have appended their signature on the impeachment motion, then it defeats logic for them again to preside over the public participation exercise, where they choose who speaks and what even goes into the content of those proceedings. So it's only fair that maybe the office of the clerk or any other body should preside over public participation. Otherwise, there would be no unfairness if the very person who is accusing you is the very person who is collecting views, compiling reports, then purporting to say this is what the public are saying. And we'll be able to demonstrate that indeed most of the people that were against the impeachment were either bad, they were beaten up, and were not allowed to give their views. My learned friend, Mr. Mwangi, will take you through the rest.
I'll address the question. The question, what is the position of the governor's political comment in view of Articles 179 and Sections 30 of the County Government Act, in light of the governor being the chief executive officer of the county? My learned friend, Mr. Mutuma, in his opening address, mentioned clearly that the governor has two caps. He has the policy and the technical cap when it comes to execution of his functions. The process of election of a governor is a political process. She canvasses for votes like any other political leader in this country. He's still a political leader. What the governor has to do is to balance between being a politician and being a manager. And Section 30, subsection 2, clearly stipulates what is the function of the governor and which appeals to the political side of a governor, the charisma of a governor, the community organizational skills of a governor. It appeals to the leadership skills of a governor. One of them, the governor is required to promote the competitiveness of his county. His county must shine, and can only shine through her charisma and how she speaks often about her county. She must promote democracy within the county, and that's an edict of the law. So the fact that the governor is a chief of executive officer of the county does not in itself mean she cannot make a political statement. Honorable Chairman and honorable members, many occasions the governor is invited by communities and she is told, we have an issue, we need to have a conversation. She goes to the ground and questions are raised impromptu. At the spur of the moment, the governor will have to make a statement. What Mr. Mutuma indicated is a calling for the governor to inspire hope where there is hopelessness, and also to give a word that we hold the community. And Honorable Chairman and Honorable Committee, we are going to demonstrate many occasions of this nature, and some of them have been blown out of proportion, but we are going to show how the governor dealt with those situations. She's been termed passionate and emotional, but she's not been unable to manage her emotions and her passion, but she has used her passion to be a better manager and a better politician and a speaker for her county. We are going to demonstrate this with evidence. On the issues, unless there is an issue we have inadvertently forgotten to address.
You're welcome. Yeah, anything
Chair.
you forgot? Yes, Vice Chair.
Thank you. I just want to seek clarification from the Council of the Governor. You said that the Governor has already dispersed the 10 million to 45 wards. Might you be knowing if it was directly through the MCS, and if they've already used this money in development so that they can demand for more?
Yeah, the Council for Governors, there's a question here you are dodging. You asked public participation.
Public participation. Who drives? The one which you are executing as the governor. And then finally,
you responded, but you circumnavigated. What I asked was a question of legality. Who is supposed to carry out public participation, legally speaking, on any matter that is being executed by the county assembly? Does the law give provision contrary to what the assemblies have done in terms of executing public participation, legally speaking?
Esther?
Thank you, Chair. My further clarification is to the council representing the county assembly. I heard you say that not a single politician has complained in writing about being disrespected by the governor. Okay, this is not to the one representing the county assembly, the one to the governor. Are you confirming that the allegations are hearsay? And the second concern, and now this is to the council representing the county assembly of Meru, did Meru MCAs have instructions to represent the leaders who are mentioned adversely by the governor as presented? If not, how do you want this committee to treat such evidence? Thank you, Chair.
Yes, members, just a little bit of guidance. You are raising very important issues. These were the opening statements. Evidence will come. Then we are going to pursue the evidence one after another one when it is not too clear. So maybe we could hold our horses at this stage. We wait for evidence.
Chair, just quick.
Yes, but something is banning the governor of Migori.
The senator.
The senator.
Yeah, I think that, Chair, it's very critical that the council did say that the political statements that the governor is overly accused for, and I think they form base of the charges, and to the extent that some of them touch even in on Article 73 of the Constitution. The question I was asking, and counsel, if you may listen to this carefully, the reason why I invoked Article 179, Sub-Article 4, and Section 30 of the County Governments Act is what the council opening statement implied was that we shouldn't hold the governor accountable on the basis of political statements. And that is, and if that is going to be the base of the conversation that will come, even in the evidence that we get as we go through this proceeding, that's what I was asking. That are you suggesting that the political statements are not subject to any accountability metrics under those two provisions of law that are quoted? That's all I wanted to know. That's what you intended to imply.
Chair.
Very well. So we had guided. Yes.
Chair.
You have something, Bunny?
Yeah, Chair. I needed to know whether we are still retaining our question hour, that we still have it later on. All right, but just one more for the council representing the county assembly. Are they holding brief for the senator and the CS so that it goes on record? And if they have records to the effect that the governor is fighting the senator, the CS, are they here representing the people they have mentioned?
Yes, that's why I was saying, senators, these are opening remarks. When the evidence comes in, probably they'll come with an affidavit sworn by the Minister for Agriculture and sworn by the senator that those things are